Thank you. During this webinar, China IPRSME Helpdesk IP Business Advisor, Mr. Matias Zubimendi, will provide an overview of the new patent law, focusing on the key amendments it brings and their importance to EU SMEs, especially to tech incentive SMEs in terms of application and patent infringement. Before we start, let's get used to 3 important functions of Zoom, the platform that we are using. These functions are the ones that you are going to use to interact with the speaker: chat, hands up, and unmute. From the bottom of the Zoom platform, you can see chat. During the presentation and discussion part, you can leave your questions or your comments in chat. You can also see participants. Click on it. You can see yourself on the top of the list of participants. You can unmute or mute yourself, and then hands up. During the Q&A section, you can raise your hand, unmute yourself, and talk with the speaker directly. Please allow me to shortly introduce the European Union Chamber of Commerce in China shortly. The Chamber was founded in 2000 by 51 member companies that shared a goal of establishing a common voice of the various business sectors of the European Union and European business operating in China. The Chamber is a members-driven, non-profit, fee-based organization with a core structure of 26 working groups and 8 fora, representing European business in 7 chapters, operating in 9 cities in China. The Chamber is recognized by the European Commission and the Chinese authorities as the official voice of European business in China. Our services can be summarized as advocacy, business intelligence, and community. Advocacy. On behalf of our members, we advocate to relevant Chinese government and agencies their key concerns and recommendations regarding regulatory environment in China. Business intelligence. We bring our members about market trend. Today is a vivid example of our business intelligence service. And community. As a member, you will be part of a network of more than 1,700 members, representing foreign invested enterprises of all sizes from a wide range of business sectors operating across China. Now, I would like to invite Ms. Jennifer Chao from China IPRSME Helpdesk to give a short introduction on IPR Helpdesk.
Hello, good afternoon. This is Jennifer. I'm the project officer at China IP SME Helpdesk. I'm very glad to introduce our organization, and the China IP SME Helpdesk is the European Union funded project. It's designed to help European Union SMEs with the intellectual property right issue in mainland China, Hong Kong, Macau, and Taiwan. This project offers a variety of services that enable EU SME to make informed decisions about their IP rights. And all these services are free of charge. We provide our services, well, inquiry helpline, events, and also offering business tools and solutions on our website. The inquiry helpline is for EU SME to ask us any IP related question, and you will receive a reply with 3 working days. So just send us the question to this mailbox. Our help desk also organizes training seminars and live webinars all over China and Europe, covering various topic range from basic IP training to tailor-made seminars on specific issue, just like this time. Normally, we organize these events together with Chamber of Commerce, business associations, cluster organizations, and embassies. So please feel free to contact us about organizing events. All event schedules are available on our website. Besides the event calendar, actually people can find various resources on IP issue, including more e-learning modules or podcast, infographic, case studies, etc. Our website also contains a comprehensive library of IP guidelines, which is covering all major IP topics, consist of trademark, copyright, patent, and trade secret. We also offer some industry-specific guides, such as IP in Industry 4.0 or cybersecurity law and IP protection, as well as details like how to remove the counterfeit products from e-commerce or protecting your IP on trade fair, etc. That's all about us, and you are always welcome to send us inquiry to the helpline at any time. And next, before give the floor to the speaker, this is my great honor to introduce him, Mr. Matias Zubimendi. Matias is the IP business advisor at China IP SME Helpdesk, where he advises European SME on intellectual property right matter. He holds a master's degree in Chinese civil and commercial law, plus a master's degree in intellectual property law. Matias has a strong background in both business development and IPR protection, as well as extensive experience in terms of legal affairs, patent, and trademark issue. Now, I give the floor to Matias to share his knowledge of today's topic. Matias, please.
Thank you, Jennifer. Welcome, everyone. This is our presentation today. We are going to discuss all the topics related with the new patent law, how these new changes are going to impact the European SMEs, so actually every SME that is settled in China. We will focus mostly on the law itself. We will analyze case by case what are these new changes, and we will try to predict what are going to be the new outcome. This law is going to come into effect next June, so we still have some time till we can finally see the results. But hopefully we will be able to predict a little bit what is going to happen. Today's presentation is, you can see the table of contents. I will do a brief introduction to patents. Then we will see the changes that are specific for design patents. We will analyze the pharmaceutical patents and what is relevant for the pharmaceutical sector. We will proceed with some analysis of the enforcement of some new changes and how this is going to impact on the legal practice of patents. Then some aspects related with commercialization and more from the business point of view. And finally, what I believe is the most significant change is the administrative delays and the possibility of extending the protection period of patents. Finally, some takeaway messages as a way of summarizing what was the main changes of this new law. But let's start with a brief introduction to patents. In China, we have two different types of patents: innovation patents and design patents. Innovation patents are the ones that protect innovation, that protects new technologies. They could protect not only new products, but also they can protect procedures, ways of manufacturing a product. The requirements for getting an innovation patent are quite simple. The first one is novelty. This means that the technology should be new. By that I mean that it shouldn't be known by any other company. It shouldn't have been published or disclosed without an NDA, a non-disclosure agreement. The second requirement is the non-obviousness. This means that if an expert checks all the state of art, this means the existing technology at a certain period, it shouldn't be obvious for him or her to came up with this new technology. So that's the innovative part, or the really innovative part of the patent. Finally, the last requirement is the industrial application. This means that this new technology should be able to be replicated in an industrial environment. Again, we're talking about products, but also procedures. What's the current protection term for a patent today? The term is 20 years from filing. This means that a company, when files a patent, the protection, the longer it can last is for 10 years. That's why, and this is a very important topic because it was affected very much for the changes of this new law. Currently, the longest period of protection term that a company can expect is 20 years. However, we'll see that this protection term can be extended in two different ways, and in one of these cases, in a certain specific industry field. But how to apply for a patent in China? We have two different ways. The first one is going directly with the Chinese National Intellectual Property Agent. This means that we go directly to the patent office and start the application. For those companies that are not settled in China, it is mandatory to have a local patent agent. For those who are settled in China, technically speaking, it's not necessary. However, due to the complexity of the application procedure, it's highly advisable to have an expert on our side for guiding us in this procedure. It is very important for foreign companies to understand that when the patent was, the claims of the patents were written in a different language than Chinese, that the translation should be done. It is advisable to do the translation not with a translator, but with the IP agent, because the specific characters that this person is going to use and the language, the level of technicity that the language requires should be done by an IP expert more than a regular translator. The registration process today takes between 4 to 6 years. Currently, there is no protection in the case of patents for this period of time while the patent is being granted. So once the application is started, till it is granted, companies do not have any type of protection. And if we consider that the protection term lasts 20 years from filing, this means that actually these 20 years of protection are not 20 years for real or in practice. So it is very important to get all the documents and make all the claims, when writing the claims, make everything very clear so we can get the patent as soon as possible. There is a method that companies use for overcoming this lack of protection during the registration period of time. What they do is to file what is called utility models. Utility models are so-called small patents because they share exactly the same requirements. However, because the examination that utility models go through is much less strict, there's only a formal analysis more than a substantial analysis. So they are normally granted in less than a year, or maximum 1 year. So the technique that companies use for getting this type of protection, or for getting protection while the patent is being granted, is that what they do is start a parallel registration, and while the patent is being granted, then they use the utility model as the IP for protecting the technology. Once the patent is granted, they simply discard the utility model and keep using the patent. The second alternative for protecting patents or for filing a patent in China is with the PCT agreement. As you may know, the PCT is an international agreement that allows companies that are part of the member countries of this international agreement, which is all the countries in the EU and also China. They allow these companies to extend their patents to certain jurisdictions, but they can start the registration in their own country, in their own language, and then it is extended through the international office to the country where the countries that they chose, basically. The costs are higher for this type of protection. However, it is a cheaper alternative if the company wants to do the registration in several jurisdictions, because otherwise they will have to hire a local attorney in every single country, and this way they can just, by clicking the different countries where they want the registration, and of course paying the extra fees, they can have this registration in several jurisdictions. The PCT agreement also, it takes longer than going directly with the Chinese Patent Office. This is rational, taking into consideration that the PCT registration has two different phases. The first one is the international phase, in which the international office makes some analysis and then sends all the results to the national office of the country where that was chosen for the registration, and then begins the national phase. This is that the analysis, it's done like if the presentation was directly filed in the country. For the PCT, again, we don't, technically speaking, we don't need in our case a Chinese patent attorney. However, if there are some comments from the patent office during the registration, then we will need to have a local attorney for replying those comments. The second type of patents are design patents. What they do is to protect the aesthetic aspects of a product. They simply protect how they look, no what they do. There's no protection of any type of technology. It's simply the cosmetic or the visual aspects of a product. Today, the protection term is 10 years from filing. Again, by today, I mean that till the 1st of June of this year, because this is one of the main modifications. But yeah, today I have to say that still the protection term is 10 years. The requirements are novelty and no functionality. Novelty means that the design shouldn't be known by any other person or company, shouldn't have been disclosed. And non-functionality means that it's only an aesthetic aspect of a product, but they shouldn't contain any type of function or usage. Otherwise, we should protect this with either an innovation patent or utility model. And how to apply for a design patent? Currently, there's only one method, that is going directly with the patent office and start the application with them. But let's talk about the new changes about design patents. The first main change is that now it is possible to register a partial design. A partial design means that it is a sector or a part of a more comprehensive design. Currently, the scenario is that if we want to protect the design of the product, we have to submit all the documents, including the drawings and pictures of the entire product. So companies cannot do the registration, leaving, for example, some blanks in a certain part of the designs in order to be updated or modified. Those companies that have complex designs for their products, in which, for example, they want to include the brand in a certain part, a draw or the logo in a different one, but they want to keep one part of the product as in blank or empty, so they can be changing time. They can change it time to time. Today is not possible. Every time there is even the minimum modification, they have to do the entire application again, and of course paying the fees. With this new law, now it is possible, it will be possible to register these partial designs. This will allow companies to, when making or designing the product, simply by writing lines with dots to make space in the middle, for example, so this part is kept out of the protection and eventually could be filled with a different type of design. So from the marketing point of view, it's going to be easier for example, combining different designs to update new versions of the product. Even in designs for software is particularly useful, because when designing, for example, a website or the graphic user interface, is going to be possible to make the main design in a way that the different parts can be changed and updated all the time. I think this is the most significant usage or the most relevant impact that we have for SMEs. The second change is that the protection term for design patents was extended. As I mentioned before, currently the protection term is 10 years, but has been modified to 15 years. So those design patents that expire before the 1st of June will be expired, but those who have an expired date after the 1st of June should have a longer protection, 5 more years of protection. Why is China doing this modification? One of the reasons that we believe it is because they are preparing the legal background or the legal framework in China in order to join with the Hague Agreement in the future, and this way this could become eventually a new method of protecting design patents, not only by applying directly with the Chinese National Intellectual Property Agent, but through an international agreement. The next part or the next main change that this new patent law brought is related with the pharmaceutical sector. They also include a patent term extension, but it doesn't work directly or automatically, but this should be approved and required by the interested party and should be approved by the State Council. This patent term extension only affects to drug-related patents. The requirement or the reason or for what they can request or a company can request this patent term extension is to compensate for the time taken by the Chinese authorities for the review and marketing approval of the drugs. This is that when a company gets a patent and they start applying for the marketing approvals in order to be capable of commercializing the drug in the country. If it takes longer than what it should take, then they can request this patent term extension. So the protection term of the patent is longer, and it makes profitable and reasonable to apply for a patent and sell the drugs. So the reason behind this patent term extension is to incentive the pharmaceutical sector to keep developing and innovating in drugs, in medications. However, there are two limits. The first one is that the term extension that is required cannot be longer than 5 years. This is that even if the approval of the marketing approval takes 6 years, then the extension term cannot be longer than 5 years. And also, the total life of the patent cannot exceed 14 years. So, as I mentioned, we have two different limits, and any request that the interested party make cannot be more than or cannot be longer than these two limits. And as I mentioned before, requesting this term extension, it doesn't mean that it will be automatically applied, because the State Council has to approve it, and they will most likely analyze case by case what is going to be the how severe or how strict they're going to be when analyzing all the document and what is understood as a delay from the authorities when making this marketing approval. Sadly, we still cannot know how it's going to be implemented and how strict the authorities are going to be, because as the law didn't come into effect yet, so we don't have precedents to analyze. The second main change is the pharmaceutical patent linkage system. For understanding this change, first I would like to explain what the border exception it is. The border exception was introduced in the third modification of the patent law in 2009. It allows those companies that want to get the marketing approval to import or manufacture or use patented medical devices or medicines for the purpose of getting that approval. This means that a company that do not have a patent on a certain specific, let's say, medical device, but needs to manufacture it in order to either get their own approval for their own product, or considering that the patent that is protecting that medical device is going to expire and the company wants to get the approval immediately after that this patent is dead, then what they can do is to obtain or start applying in advance for the marketing approval, and they're allowed to manufacture or import these patented medical devices and use them without being considered an infringement, so they can get the approval immediately after. This modification was done in 2009 and is called the border exception. Now the new law goes even further. In the Article 76, what they do is to implement a dispute resolution method for this type of exceptions, or to be sure, so companies can be sure that they are not making an infringement. What is possible for both the drug applicant for marketing authorization or the patent holder is that they can file a lawsuit in order to request to people's court if the marketing authorization that is going on will also mean a patent infringement. And I'll give you an example. Let's say company A is filing, company A is the holder of a patent. Company B wants to start the marketing authorization for a certain specific product. Company A can request the People's Court that they want to know if the marketing approval that company B started, it is considered an infringement of their own patent. This way, they can, if they are talking about an infringement, they can request to the State Council that this marketing approval will not be granted till the patent is over, till the end of the patent protection. This method of linking a marketing approval directly with a specific patent, and that this connection is done by the Chinese authorities and is what is implemented in this new law. This way, companies or patent holders can proactively check what type of marketing approvals their competitors are trying to get, and be sure and block every time that the competitors are trying to overstep in their own patents. As I mentioned before, this type of applications can be started either by the patent holder or also by those who are applying for the marketing approval, because it may be the case that they also want to be sure that they're not infringing any patents, so they don't have to pay compensations to anyone and just wait till the patent is over. And they can request to the State Council and the Patent Administration to provide them with specific measures for connecting these patent dispute resolutions and the approval with the approval of commercialization. This way, they will be sure that they're not infringing any patents, that if they just follow the rules given by the Patent Administration, they will be completely sure that they are not going to have to compensate anyone. And at the same time, as soon as the patent is over, they will be able to commercialize the product without any problem. The next part of the next change, significant change of the new patent law, is related with the patent enforcement. Basically, what we have is an increase of damages that companies will have to pay if they infringe any patents. We see that an increase of punitive damages, that is up to 5 times the original damage, is to sanction bad faith acts. Statutory damages are the one that does not base on the real damage, because sometimes they are too difficult to calculate. So the new law, what they did is to increase the statutory damages up to 5 million renminbi. What is very interesting also is that now judges, either from People's Court or Intellectual Property Courts, they have a new capacity of requesting to the interested parties to provide proofs for determining the real level of damage. Let's say that one company claims that they suffer certain amount of damage due to a patent infringement. Then the judge can request proactively that this company have to prove that this is actually the real damage that the company suffered, and that the amount that they are claiming responds to a very specific or reasonable calculation done by them. So the judge can actually request companies to show their account books as well as any other information. And if the company do not want to disclose or this information, or if they falsify it, then also the judge has the capacity of deciding the final amount of damages by simply using the information provided by the other party, this means by the infringer, which would be very unfortunate and for the party that is claiming the damages. What we can see as well is that this new law wants to increase the role of the administration when protecting the intellectual property rights. What they're trying is to create a combined IP enforcement method with both the administration and the judicial system. This can be done specifically when they give to the state council and local governments the capacity of requesting the intervention of the China National Intellectual Property Agency for those cases that may have a national impact. So when we are talking about an infringement that has the potential of affect the entire nation, then the authorities have the chance to call the experts, the real experts of intellectual property rights, which are the members or the employees of the national agency. So they can provide a better analysis, they can provide a better feedback, and they can take care of the scenario or to analyze the real infringement in a better way than maybe local governments, for example. So when the message is that when things get really big, when they reach a national level, then the experts will take control. So there is a more professionalized and more efficient method of protection. Regarding commercialization, there is a very significant change as well. That's a new institution, a new opportunity, let's say, for those companies. That is the so-called open license system. The open license system, basically, it's that now companies will be able to request the national agency that they want to put their patents into a public offer. Let's say they want to allow anyone that wants to use their patents just by setting fixed fees, they will be able to get the license. how can companies request this type of open license system? The first requirement is that they should provide a written statement. This written statement should include what's the license method. They should include the fees. This means that how much money per month, per year, or any period of time a company should pay for getting the license. And the third requirement is that this type of licenses should never be non-exclusive. This means that many companies, even if they are competitors, they should all be able to have access to the license and to the patent as much as they only have to pay the fees. If they pay the fees and accept all the other conditions, then they all should be able to have access. What the law here is trying to do is to promote the access to new technologies. This written statement should be given to the Patent Administration Department of the State Council, and it can be withdrawn without any problem. It's again with the written statement, just with the same authority, just claiming but the opposite, that I don't want people to be capable of getting a license under these conditions. However, when a company will withdraw an open license patent, the effects of this withdrawal will only affect to future licenses. This means that those that were already granted and that they were granted for a certain period of time, they should be respected, and they cannot be cancelled or modified, or the conditions cannot be changed. What can be set as an open license? Companies will be able to set innovation patents, utility models, and design patents. In the case of innovation patents, there are no extra requirements. However, for utility models and design patents, because they do not have in their own registration process a substantive analysis, what authorities are requiring is that they will need a patent right evaluation report to be provided before being approved for the open license system. As I mentioned before, what the authorities are trying to achieve with this new open license method is to promote the access to new technologies. And they are also offering benefits for patent holders in order to incentivize them to adopt this type of licensing. The first and most obvious incentive is to reduce or even exempt patent holders for the payment of the annual fees, so they can keep their patents free of charge, basically. However, they will have to offer them to the public. But also, the other benefit is that this method will, or I believe it will increase massively how easy it is to, or will be to commercialize a technology. Since all the procedure is quite transparent and public, it will be easier for EU companies that have a patent in China just to offer them to Chinese companies and getting some profit out of that. One of the main difficulties that EU companies are facing or face when coming to China is that they do not have the network in order to sell the technology properly, and it's always an investment to pay and for someone to look for contacts and potential clients. And this way, even though it's not going to replace entirely the importance of having a commercial agent here, it will also be a new method of gaining visibility and getting more chances of making some profit out of our technology. There is also a dispute method that is implemented when there is a problem between this among this open license system. The main rule of this new patent, of this dispute resolution method is that parties must negotiate and solve the issue by reaching an agreement. Of course, there is an exception. That is that if negotiations fail, they can request to the Patent Administration Department that belongs to the State Council to mediate first, and then eventually, if there is no possibility, parties can bring a lawsuit to People's Court. So again, to summarize, the first rule is negotiation. If the negotiations fail, the State Council gets involved and trying to make the parties reach an agreement. If not, companies should go to court and solve any dispute that they have. The next significant, and I believe the most important modification that the new patent law brings is the possibility of get a term extension due to administrative delays. This should not be confused with the extension for pharmaceutical patents. This is a different case for different scenarios. It can be applied not only to drug patents like the pharmaceutical term extension, but this can be applied to all type of innovation patents. It is only innovation patents, not for utility models, not for design patents, but for all innovation patents, not only pharmaceutical ones. What are the circumstances for requesting this term extension? The first one is that 4 years should have passed from the application date, and 3 years should have passed from the request that the party made for the substantive examination. In a patent registration process, we have different steps. The first one is the filing or the application itself. Then there is a formal examination, and finally, after paying some fees, the companies can request for the substantive examination. If the companies have already paid this fee and made this request, and 3 years have passed, but also 4 years have passed from the application date, then we are in the scenario in which we can request this patent extension. The limit is that the delay should not have been caused by the applicant. This is that, for example, the company requested the substantial examination but never pays the fees for that, and it takes due to a problem, even though if that problem is not entirely the fault of the applicant, but let's say the bank that the applicant is using, then the delay is not caused by the authorities, so there's no chance of requesting the patent term extension. So again, the delay should not be caused by the applicant. Otherwise, the time lost is already lost. So what's the difference with the previous one with the term extension for drugs? Is that these delays are for all kind of innovation patents, and they can coexist, technically speaking, with the pharmaceutical extension term. This means that a pharmaceutical drug that is being delayed can be requested both a term extension both for the administrative delay and both for the marketing approval. However, even though this is technically possible, due to the limitations that the pharmaceutical patents request, it's very unlikely that a company will face that scenario, and the term extension would be very short. So even though it's technically possible, in practice, it's very unlikely that we have an impact, or that both will be applied at the same time. That they will have an impact because for this pharmaceutical company, this term extension is very relevant, and for any company willing to obtain an extra and a grace period for the own innovation patent is going to be, could be the difference between a business plan or not, having a business plan or not. So some takeaway messages is that companies should extend their protection term of patents whenever it's possible, because this way they can make more profit, they can make more money with their own patents and their own technology. Companies, especially pharmaceutical companies, should always check regularly the commercial approval of drugs, even if not their own, but the ones from the competitors, because they should be checking if any of these application is or could be considered a patent infringement, and if it is the case, they should start the linkage system dispute method, so they can link the infringement with their own patent and block it for the, or block the approval till the patent is dead. The third takeaway message is to enforce the patents anytime when there is an infringement. The fourth one is to register your designs as soon as possible, because as I didn't mention, but in the case of China, unregistered designs are not or do not have any type of protection. So register them as soon as possible, and do partial designs when you are modifying all designs. So you can get the possibility of having a design that can be updated regularly, that you can update some part and leave the rest as it is and protect it. So those who are registering their designs, they should learn how to do them in the most efficient and effective way as possible. Finally, the last takeaway message is that if you have any doubts, you can contact with the China IPRSME Helpdesk. You can see in our screen the email. And yeah, we normally, we're a helpline that is free, fast, and confidential. I will normally reply within 3 working days. So let's proceed with the Q&A section.
Okay, thank you very much, Matias. Thank you for the informative presentation, especially the comparison from the upcoming patent law, and also what's the difference from the existing law. And now we are in the Q&A section, and please type your question in the Q&A box, or you raise your hands, and we can please ask the question to Matias directly. And let's see whether anybody have any questions. Okay, there's one question. The question is, I've created a design just last month, and I want to patent in China. How can I still take advantage of the longer protection term of 15 years? Matias, do you have any advice?
If you have created the design and you still haven't registered it, then my advice is to wait for the new patent law to be enforced to do the registration. Of course, this will depend on your business plans. If your company needs to start commercializing the product as soon as possible, maybe you cannot wait, because as I mentioned, unregistered designs do not have any type of protection. One of the requirements is novelty. So before doing any commercialization, you have to do the registration. But if you can wait, I will wait till this new law comes into effect. Otherwise, if you start the registration, you will still have the certain level of protection for 10 years. Most likely, it will be extended automatically till 15 years. This is something that we still don't know, because it's, as I mentioned, we haven't seen any case that we can quote as a precedent. However, yeah, we believe it's going to be this way.
Oh, okay. Thank you, Matias. Means because the existing patent law, so we still the company is still until June.
Yes.
And,
exactly. Till the 1st of June, if it is possible, it's best to wait.
Yeah. Hello.
Next question.
Jennifer and Matias, I see a question in chat.
Yes.
Yeah. The voice is low though. Jennifer, we cannot hear you clearly.
Okay, sorry. What's the difference between innovation and design patent? So Matias, would you please give more details about it?
Yes, of course. Even though both of them are called patents, they are very different. Innovation patents, what they do is to protect new technology. They protect the product, the technology involved in the product. For example, let's say you have a cell phone, they protect how the cell phone works, how it connects, the screen, how it, the battery is charged. There's a lot of patents in a phone. In the case of design patents, what they only protect is the aesthetic aspect of a product. This means only how it looks. Let's say again with the example of the phone, the protection would be where the screen is located, where is the keyword, if there is a keyword, if there is not, the fact that there is not, what is in the back of the phone, where is the camera located, where is the charger located, only how it looks. If we are, for example, in a scenario in which the location of the camera in the product, it actually contains or gives certain benefit to the product, it makes the camera to work better, then this is not aesthetic. This has an impact on the competitive aspects of the product, on the efficiency of a feature of the product. Then here we are talking about innovation patents. So this is the main difference. Everything that is purely aesthetic and ornamental, it goes with the design patent. Everything that is technological, that it has an impact on the efficiency of a product, it goes with innovation patent. I think I hope it was clear, but if I have to develop more, please let me know. There's no problem at all.
Yeah, thank you, Matias. So if you still have more questions about the difference between innovation and patent or have any reference, you can also send to our inquiry hotline. We can give you the answer. Okay. Next question is about software. Okay. So it's about the software. Are there any particular things to consider when try to patent my software solution in China? So it is also about patent, right?
In the case of China, software, it is mostly protected by copyright. So this is the big rule, that if you have a software, you have to protect it with copyright. You have to register the source code of the software, and technically speaking, you're protected. Nevertheless, in very specific circumstances, it is possible to protect the software as a patent. Here, the software should be implemented in a more complex procedure in which the hardware is not capable of reaching the technical solution that the patent is trying to solve without the assistance or the help of the software. So the software is also part and the main part of a more complex process. Registering a software as a patent is very complex. It requires a lot of analysis and the expertise of a very good patent attorney for getting the approval for the software patent. Said this new law do not bring any significant change on software patentability. It was expected to bring some, but we don't see any relevant modification. So most likely it will happen in the future, or it can be, or maybe we will see some modifications in the implementing rules of the law.
Okay, thank you, Matias. Did anybody have questions to the question about the presentation today, or you already have a question about any, let's say, IP issue? You can ask here, or send us an inquiry to the inquiry hotline afterwards. It's both are fine. Let's see. Okay. As Matias, you mentioned about open license. So why should an SME choose an open license option? It is possible to opt out of the after some years of using it. Matias, please.
Well, as I mentioned in the presentation, there are two main benefits of opting for the open license system. The first one is the tax reduction or exception that will allow companies to not pay the annual fees of a patent, which sometimes, especially for SMEs, can be out of budget. So that is the main benefit. The second one is more business oriented from the commercialized point of view, because it will increase the visibility of a patent simply because it will be published by the national agency. So it will be easier for those companies that are seeking new technologies to see them. It's going to be clear and very easy to obtain a license without even having to start a negotiation, just by simply paying the fees and use the technology. So I believe this is an opportunity for those companies that sometimes they hesitate if it is worth or not to apply for a patent, because they don't know if they will be able to make profit out of them. So maybe this could be something that will push them to finally do the registration in China, so they know that they can easily commercialize. They don't have to network that much. I'm not saying that this is going to replace having a commercial agent, but just that the visibility and the negotiation will be way much easier, and hopefully it will increase technology transfers a lot.
Okay, thank you, Matias. Okay, we just explained about the innovation patent and design patent. Now we have another question regarding the utility patent and the design patent. In terms of the utility patent, the same as design patent? Would you please advise?
Yes, it's not. Utility models are not the same as design patents. Utility models are also for innovations and technological or functional aspects of a product, while design patents are only for aesthetical aspects of a product. Utility models are so-called small patents. This means that they share the same requirements. However, the extent of how strict is the agency when analyzing the requirements is much less strict with utility models. That's why they're faster to be obtained than with innovation patents. What it may happen in other jurisdictions is that we have design models. The design models, but this is not the case in China, I'm talking about different jurisdictions, are the three-dimensional designs. They're called this way. That's why you may be confused. However, in the case of China, we only have design patents for two-dimensional or three-dimensional products, and innovation patents and utility models for technological and functional aspects of a product.
Thank you, Matias. Let's see whether anybody else also have other questions. If not, it's about the time of today, and let's finish the Q&A section.
Thank you, Jennifer. Thank you, Matias.
My pleasure.
Thank you, dear participants, for attending our webinar on new patent law. Please know that we care about your well-beings, and we hope our event will help with the development of your company. If you have any questions in the future, please contact us, and we will share the PPT today also to your emails. If there are no more questions, we shall conclude the event. Yeah. Have a nice day.
Thank you. Thank you.
Thank you, Jennifer. Thank you, Matias. Thank you for your support and participation. Thank you.
Thank you to you. Have a nice day.
Have a nice day. Bye.
Bye-bye.